Welcome to this webinar presented by the It's My Choice project from the Barbara Schleifer Commemorative Clinic. The It's My Choice project is funded by the Department of Justice Canada. This webinar is one in a series that gives basic information about areas of law that may be helpful for survivors of gender-based violence. This webinar will focus on a basic overview of family law in Ontario. The information in this webinar is current as of March 18, 2026. Please note that this webinar is designed to provide legal information and does not give legal advice about any specific situations. If you or someone you know has specific legal questions, it is best to consult with a lawyer. If you need help finding a lawyer, you can contact your local legal aid clinic or the Barbara Schleifer Commemorative Clinic. Let's begin the webinar. It is important to begin by discussing what constitutes domestic violence or family violence in the family law context. In 2021, there were legislative changes to the Divorce Act and Children's Law Reform Act, which define the term family violence very broadly and understand it to include any conduct by a family member towards another family member that is violent or threatening or that constitutes of a pattern of coercive and controlling behavior, or that causes that other family member to fear for their own safety or for the safety of another person. So under that definition, family violence would include 1. Physical abuse, meaning actual or threatened physical harm, including forcible confinement. 2. Verbal abuse, which includes name-calling, put-downs, or insults. 3. Financial abuse, including withholding money, stopping a partner from getting a job or from keeping a job. 4. Sexual abuse. 5. Harassment and stalking. And 6. Psychological abuse, which includes intimidation, social isolation, meaning to keep a partner from contacting their family or friends, and threats to harm or abduct children. Common family law claims. This is an overview of some of the different kinds of family law claims. The first is decision-making responsibility, which used to be referred to as custody. The legislation was recently amended and all references to custody were changed to decision-making responsibility. Often, clients come to us stating that they want to seek custody for their children, and what they are referring to is decision-making responsibility. 2. Parenting time. This used to be referred to as access. At the same time that custody was redefined as decision-making responsibility, access to children was redefined as parenting time with children. 3. Restraining orders. 4. Child support. 5. Spousal support. 6. Division of family property. Decision-making responsibility. The first and most crucial family law claim is decision-making responsibility, which used to be referred to as child custody. Decision-making responsibility refers to the responsibility to make significant decisions about a child's life and well-being. Those decisions may relate to the child's health, education, religion, and other important matters. Sole decision-making responsibility is when one parent makes the decisions without having to consult with the other parent. Joint decision-making responsibility is when the parents share decision-making responsibility. For joint decision-making responsibility to work, parents must be able to cooperate and communicate, even with each other, though they are not together. Often, joint decision-making responsibility is not appropriate in cases of domestic violence because, 1, it requires frequent communication and contact, and 2, it requires a degree of trust, civility, and respect that is often not present in cases of domestic violence. Some of the things that the courts look at in determining decision-making responsibility include 1. Who is the primary caregiver? Who attends to the child's physical and emotional needs? 2. Who arranges daycare, doctor's appointments, etc.? 3. How are major decisions made, such as which school the child will attend? 4. What is the child's relationship with extended family members, such as grandparents, aunts, uncles, etc.? 5. Are there any siblings or half-siblings? What is their relationship like? Courts do prefer to keep siblings together. 6. What is the child's current schedule? For example, are they in daycare, school? Do they have extracurricular activities? Does the child have a routine? 7. How close is the school or daycare to the home? 8. What is the parent's work schedule and what arrangements have been made to care for the child? 9. Where does the child currently reside? 10. How long have they lived there? 11. Who is the child's family doctor? Who attends at the child's appointments? Does the child have any health concerns? 12. Are there any concerns about the child's development insofar as it affects education? For example, does the child have a disability? 13. Does the client have a new partner? If so, for how long? Describe the relationship between the new partner and the children. 14. Does the child have a passport? If so, who has possession of it? The term primary residence means the home where the children live most of the time. If there is a sole decision-making responsibility arrangement, that parent will likely also live at the primary residence. The best interest of the child analysis is the key legal principle in child-related claims in family law matters. When deciding the child's best interests, the courts prioritize the child's physical, emotional, and psychological safety, security, and well-being. Courts will consider a number of factors, including 1. The child's needs, given the child's age and stage of development, such as the child's need for stability. 2. The nature and strength of the child's relationship with each parent, each of the child's siblings and the grandparents, and any other person who plays an important role in the child's life. 4. The history of care of the child. 4. Each parent's willingness to support the development and maintenance of the child's relationship with the other parent. 5. The child's views and preferences, giving due weight to the child's age and maturity. 6. The child's cultural, linguistic, religious, and spiritual upbringing and heritage. 7. Any plans for the child's care. 8. Each parent's ability and willingness to care for and meet the needs of the child. And 9. Each parent's ability and willingness to communicate and cooperate with each other on matters affecting the child. Most significantly, the courts will consider family violence when deciding on family law claims. This will directly inform the decisions the family court makes about the parent's claims for decision-making responsibility, parenting time, the best interests of the child, travel or relocation requests, restraining orders, and other claims as well. The court will look at the following factors when considering the family violence. 1. The nature, seriousness, and frequency of the family violence and when it occurred. 2. Whether there's a pattern of coercive and controlling behavior in relation to a family member. 3. Whether the family violence is directed toward the child or whether the child is directly or indirectly exposed to the family violence. 4. The physical, emotional, and psychological harm or risk of harm to the child. 5. Any compromise to the safety of the child or other family member. 6. Whether the family violence causes the child or other family member to fear for their own safety or for that of another person. 7. Any steps taken by the person engaging in the family violence from occurring and improve the person's ability to care for and meet the needs of the child. And any other relevant factor. Parenting time. The second major family law claim is parenting time. This used to be called access. Parenting time is the time that the child or children spend with the non-custodial parent, which is the parent that they are not primarily living with. There are different types of parenting time arrangements. 1. Shared parenting time. Parents who have shared parenting time share the amount of time spent with the child. This means that the child lives at least 40% of the time with each parent. 2. Split parenting time. Split parenting time is when parents have more than one child and each parent has one or more children living with them for most of the time. 3. Supervised parenting time. This can be arranged if there are safety concerns during visits or when children are exchanged between parents. This means someone else must be present when you visit your children. It's important to know that parents can agree on a supervised parenting time agreement, or it can be required by the court. The person supervising a parenting time visit could be, for example, a friend or relative the parents agree on, or a paid professional, such as a social worker, or a trained professional or volunteer at a supervised access center. Parenting time arrangements can be written out in detail in a parenting plan, separation agreement, or court order. They can also list specific days and times it will occur, for example, that the children would be with one parent every other weekend, or some other arrangement. Parenting time can also be left open, allowing the parents to work out a plan in a more flexible way, although it is difficult to enforce this kind of arrangement. A parent with parenting time does have the right to information from the parent with decision-making responsibility about the child's health, education, etc. But parenting time does not give that other parent the right to be involved in those decisions. Passports and other legal documents. The family court can also make decisions about which parent is able to keep or renew the child's government-issued documents. They can even allow one parent to renew those government documents without the consent of the other parent. Some examples of government-issued documents include birth certificates, health cards, and passports. Passport Canada is usually very careful about issuing passports when parents are separated. Even in cases where there is a sole decision-making order, it can be hard to get a passport for a child without the other parent's consent. This is because they are worried about one parent removing the child from Canada and not returning. Abusers also often use control over children's documents as a means of controlling the survivor parent. Therefore, it is recommended that any family court order specifically include a provision allowing the primary parent to renew the children's government documents without the consent of the other recipient. Traveling with children. In the family law context, travel means for a short period of time. It is different from moving with the child to live in a new location. The ability of a parent to travel with their child post-separation depends on who has decision-making responsibility and the parenting arrangement. It may be that the non-primary residential parent needs the consent of the other parent to travel with the child. Or there may be a court order that allows each parent to travel with the child on vacations without consent. A family court order can also include what's called a non-removal provision. This would prevent the other parent from traveling outside the country with the child. This can be very important when there is a concern about one parent abducting the child and leaving the country. Relocation. If a parent wants to move with the child to a new community far from the other parent, then they can bring a relocation claim. This sometimes needs a court order, especially if the relocation impacts the other parent's parenting time arrangement or the other parent refuses to consent. So, for example, if both parents lived in Toronto, the parties separated, and now one parent wants to move with the child to another province. However, the other parent currently has weekly parenting time with the child, and the move will prevent them from seeing the child. As with all family law claims, courts considering a relocation claim analyze the best interests of the child, and they will look at the following factors. 1. What are the reasons for the relocation? Why does the parent want to move? Is it for work? To be closer to family? 2. The impact of the relocation on the child. Is it disruptive to the child? Will the child have family and friends in the new place, or will they be isolated? 3. The amount of time spent with the child by each person who has parenting time and the level of involvement in the child's life of each of those persons. 4. Whether the parent who wants to relocate the child followed the legal rules for giving notice. 5. Is there an order or agreement that specifies the area where the child is supposed to live? And 6. The reasonableness of the proposal of the parent who wants to relocate with the child. Child support. Child support is money that one parent pays to the other parent who is looking after the child most of the time after separation. Child support is the right of the child to be supported by both parents. So what is the eligibility criteria for child support? 1. There is a minor child under 18, or 2. A child that's enrolled in a full-time education program, or 3. A child with a disability or illness. Child support is calculated using the child support guidelines. Child support determinations are focused on the needs of the child, not the needs of the parent. Child support requires full financial disclosure of income and assets, including disclosure of income tax returns and notices of assessment and pay stubs. This is in relation to the income disclosure of the parents. The Federal Child Support Guidelines are a set of rules and tables for calculating the amount of support that a paying parent should contribute towards their children. The payor parent is required to pay a set amount based on 1. His or her income, and 2. The number of children entitled to support. Generally, the primary residential parent's income is not relevant to the calculation of support. It is important to know that a parent's income can be imputed if the parent is under or unemployed, or if the parent has failed to provide the full financial disclosure. Special and extraordinary expenses. In addition to the table amount of child support, courts can also make an order about special and extraordinary expenses. These are called Section 7 special expenses. These are expenses that don't relate to food, shelter, or basic necessity. They can include things like childcare, special health programs, or extracurricular activities. This becomes especially relevant where the child has a disability and requires a lot of medical services or health care. Typically, both parents help pay for these extraordinary expenses in proportion to their incomes. Spousal support. Spousal support is the money that the wealthier spouse pays to the other spouse after the relationship ends. This can be agreed to by the parties or ordered by the court. So, who can apply for spousal support? 1. A married spouse when they separate or divorce, or 2. A person who was living with their partner at least 3 years, called common law spouses, or 3. A parent of a child who was in a relationship of some permanence with the other parent. Here are the situations where the court will order spousal support. 1. To compensate a spouse for not getting education or a job because they looked after the other partner, home, or children. 2. To make up for a spouse's lower finances after the relationship. 3. To help a spouse build up to independence without spousal support in future if possible. So, how does the court decide how much spousal support is appropriate and for how long it will last? 1. The court will look to the spousal support advisory guidelines that are suggested by the government. And 2. The court will base the amount on the income of both parties. And 3. Spousal support may be temporary or for life if a person cannot reasonably support themselves. So what are the factors the court considers when deciding on a claim of spousal support? The court will look at 1. The length of the relationship between the parties. 2. Each spouse's role in contribution to the family. 3. Are there any ongoing responsibilities to care for the children? 4. The financial means and needs of each spouse. And 5. The age and other circumstances that affect the ability to become independent for the spouse receiving spousal support. Division of family property. In the family law context, the rules for division of family property only apply to married spouses. It does not apply to common law spouses. To make a claim for equalization, the parties can be separating or getting divorced. It is designed to ensure both spouses get an equal share of the value of property and assets that accumulated during the marriage. Under what is called equalization, the value of any kind of property that was acquired by one spouse during the marriage and still exists at separation must be divided equally between the spouses. Also, any increase in the value of property owned by a spouse at the date of marriage must be shared equally. In simple terms, the first step is to calculate the net family property. So, for each spouse, you would calculate their net worth, essentially their assets minus their debts, on the marriage date and on the separation date. Then you calculate the difference between the two spouses. The result is that half the difference is paid to the spouse who has the lower net family property. It is important to note that not all property is included in these calculations. Some property, such as inheritance, may be excluded. It is crucial to get legal advice to determine what property can be included and what cannot. The matrimonial home will usually be included in the calculations. Both spouses' names do not have to be on the deed of the property for the matrimonial home to be included. Restraining orders. A restraining order is an order from family court that limits another person's behavior and actions. It can be implemented against a person who is a current or past spouse or partner you live with. The purpose of a restraining order is to help a person feel safer from someone who is harassing or abusing them. It is important to know that a restraining order can lead to a criminal charge against the person if they do not follow the order. A restraining order should always be part of a larger safety plan. A family court judge can grant an applicant survivor a restraining order if the applicant has reasonable grounds to fear for his or her safety and/or for the safety of a child in their custody. The fear can be subjective, so long as it is reasonable, and the fear can be for physical or psychological safety. Here is a list of potential evidence that may help in getting a restraining order. 1. A 911 or police report. 2. A criminal charge or conviction, peace bond, bail conditions, or probation conditions. 3. Medical records. 4. Photos, texts, emails, voicemails, etc. 5. Letters from family, friends, colleagues, or religious advisors. A restraining order can include a number of conditions. These conditions include 1. No direct or indirect contact or communication. 2. Staying away from specific locations. 3. Keeping away to a specified distance. And 4. Anything else the court considers appropriate. If someone is in breach of a family court order, it becomes a criminal offense and can be reported to the police. The police can then enforce the breach by laying criminal charges. It is also important to know the difference between a restraining order versus a peace bond. You go to family court to get a restraining order. In most cases, you can apply for a restraining order against someone if at least one of these is true. 1. You are married to the person, or you live together with the person for any period of time, or you have a child with the person. Peace bonds. If none of these situations apply, then you can go to criminal court to ask for a peace bond. A peace bond is an order from a criminal court that limits the behavior of someone who makes you reasonably feel afraid for your safety or your partner or child's safety. You can ask for a peace bond against anyone. It doesn't have to be someone you're in a relationship with. For example, you can apply for a peace bond against a neighbor or a coworker. A peace bond is a criminal court order made by a justice of the peace or judge. It is a signed promise to keep the peace and have good behavior. If someone signs a peace bond, it means they promise to follow the conditions in it and not to break the law. The restrictions in a peace bond are similar to that of a restraining order, including a ban on any contact. A breach of a peace bond can also lead to a criminal charge. A peace bond usually lasts for 1 year, but it can be extended. Family courts. The main difference between the Ontario Court of Justice and the Superior Court of Justice is that the Ontario Court of Justice does not deal with divorce or division of property. So, if a party wants to seek a divorce and/or there is significant property shared between the parties, they need to start their application at the Superior Court of Justice. Sometimes, in our experience, we find that it is advantageous for parties to file at the Ontario Court of Justice for 2 reasons. 1, faster timelines, and 2, judges typically have a better understanding of and sensitivity towards domestic violence. So, sometimes if divorce is not urgent, but if one parent wants to get the parenting issues resolved as soon as possible, we will advise them to file their family court claims about the parenting issues, such as decision-making responsibility, parenting time, and child support, at the Ontario Court of Justice. Then, once they receive final orders about the parenting issues and support, they can then file a separate application for divorce at the Superior Court of Justice. There is also a court called the Integrated Domestic Violence Court, or IDV Court. The IDV Court provides one court where families can have their family and domestic violence criminal charges heard before a single judge. Instead of appearing in different courts before multiple judges, the IDV Court will connect one judge to one family. The IDV Court will not hear claims for divorce, family property, or child protection. The Barbara Schleifer Commemorative Clinic. The Barbara Schleifer Commemorative Clinic offers legal, counseling, and interpretation services to marginalized and racialized populations of women and gender diverse people who have survived violence. The clinic offers trauma-informed legal services in the following areas of law: family law, immigration law, independent legal advice and supports for survivors of sexual assault. We provide supports for abused women who have been charged under the Criminalization of Women Project, and sexual harassment in the workplace under the Me Too Project. The It's My Choice Project. The It's My Choice Project aims to increase access to justice by providing fully integrated, trauma-informed, independent legal advice and independent legal representation to women and gender-diverse people who have experienced sexual assault and/or intimate partner violence. For sexual assault survivors, this includes criminal and non-criminal options. For survivors of intimate partner violence, this includes family law, immigration law, and intersections with criminal law. Furthermore, in partnership with community organizations across the province, sexual assault and intimate partner violence survivors will have the option to access these services remotely at satellite or pop-up clinics and on-site at the Schleifer Clinic. The Barbara Schleifer Commemorative Clinic contact information. Thank you for watching this presentation from the It's My Choice project at the Barbara Schleifer Commemorative Clinic. Please note that the information in this webinar is current as of March 18, 2026. If you have questions or would like to talk to a lawyer, you can contact the Barbara Schleifer Commemorative Clinic at www.schleiferclinic.com